Good morning, Alex and friends. I'm Grace. Today is Thursday, April 30th, 2026, and you're listening to Alex's News. The high in Riverside today is 81.0 degrees, with a low of 52.4, providing generally mild and comfortable conditions as we reach the final day of April. In today's episode, we will take a deep dive into how a recent Supreme Court ruling has fundamentally altered the framework of the Voting Rights Act. Additionally, we will explore the implications behind the Trump administration's move to dismiss the entire National Science Board, looking at what this means for the scientific community. Aside from these major developments, we have a variety of other stories to cover that you will not want to miss. All this and more coming up on Alex's News. Stay tuned. A seismic ruling out of the U.S. Supreme Court is reshaping American democracy this morning. In a 6-3 decision, the court has gutted what's left of the Voting Rights Act of 1965. For more on what this means, we're joined by our political correspondent, Ethan. Ethan, good morning.
Good morning, Grace. Yes, this is one of the most consequential voting rights rulings in decades. The case is called Louisiana versus Calais, and it was decided yesterday, April 29th. Legal scholars and civil rights advocates are already calling it the, quote, final blow, end quote, to the Voting Rights Act. And the fallout is happening in real time across the South.
So walk us through what the court actually did. What was at the heart of this case?
At the center was Louisiana's 6th congressional district, a majority black district represented by Democrat Cleo Fields. The court's conservative majority, in a 6-3 vote, struck it down as an unconstitutional racial gerrymander. According to PBS NewsHour, Chief Justice John Roberts described the district as a, quote, snake, end quote, stretching more than 200 miles, linking black communities from Shreveport to Baton Rouge. Justice Samuel Alito wrote the majority opinion.
And I understand this ruling didn't just decide one district. It changed the legal standard itself.
That's right, and this is the part that's truly transformative. For decades, plaintiffs could challenge maps that resulted in diluting minority voting power. Now, under Justice Alito's new framework, they must prove intentional discrimination. It's a much higher bar, and it essentially hollows out Section 2 of the Voting Rights Act.
Tell us more about this new test. What do plaintiffs actually have to show now?
Alito updated the long-standing Gingell's framework with 4 new prongs. First, plaintiffs must submit illustrative maps drawn without any consideration of race at all. Second, they have to statistically separate race from what the court calls, quote, ordinary partisan conflict, end quote. Third, historical discrimination is mostly off the table. They need a present-day smoking gun showing racial animus among the specific legislators who drew the map.
And there was a fourth element too, right? About legislative intent?
Yes, the court reaffirmed what it calls a heightened presumption of legislative good faith. That means courts will assume a state's motives are partisan, not racial, unless plaintiffs can prove otherwise with overwhelming evidence. Civil rights attorneys say that's a near impossible standard. Combined with the other prongs, it makes Section 2 challenges extraordinarily difficult to win.
Now there's a real twist with this Louisiana district, isn't there? Some history that makes the ruling especially controversial?
A fascinating twist, Grace. The Louisiana legislature originally drew that snake-like map back in 2024. They were complying with a previous federal court order in a case called Robinson versus Ardoin. So the state was told to create a second majority black district, and now the Supreme Court is striking down the very map drawn to comply with that order.
That sounds like a no-win situation for the state. Why did the district end up with such an unusual shape?
According to CBS News and reporting from the Texas Tribune via Houston Public Media, the Republican-controlled legislature deliberately chose that non-compact shape to protect high-ranking white Republican incumbents. We're talking about House Speaker Mike Johnson, Majority Leader Steve Scalise, and Representative Julia Letlow. By prioritizing incumbent protection over compactness, they essentially manufactured the pretext for a racial gerrymander claim. So the ugly shape wasn't really about race, it was about politics.
And Justice Kagan picked up on that very point in her dissent, didn't she?
She did, and quite forcefully. Justice Elena Kagan called it a catch-22. If a state draws a compact minority district, it may fail the new partisan disentanglement test. But if it draws a non-compact one to protect incumbents, it gets struck down as too racial. Either way, plaintiffs lose.
Tell us more about that dissent. I understand she read it from the bench, which is unusual.
It is unusual, and it signals just how strongly she felt. Kagan was joined by Justices Sotomayor and Jackson. According to ABC News and NPR, she said the majority had, quote, eviscerated, end quote, the Voting Rights Act. She argued the ruling makes it, quote, basically impossible, end quote, for plaintiffs to prove discrimination, rendering Section 2, quote, all but a dead letter, end quote. She warned this puts a half-century of voting equality gains in peril.
And she used some pretty stark language about what comes next, right?
She did. Kagan said the decision provides a, quote, green light, end quote, for states to systematically dilute the voices of Black and Latino voters. And Grace, we're already seeing that play out today. The ripple effects have been almost immediate across the South.
Let's talk about that. Florida moved fast. What happened there?
Remarkably fast. Today, April 30th, the Florida legislature passed a brand new congressional map during a fast-tracked special session. According to reports cited by Gemini Flash News, the map is projected to create a 24-4 Republican advantage. That's a net gain of 4 seats. It effectively eliminates the majority Black 20th congressional district and dilutes Democratic strength in Orlando and Tampa.
That's a massive shift for one state. What about Florida's neighbors?
Several other states are following suit. In Mississippi, Governor Tate Reeves announced a special session for May 20th, about 3 weeks from today. It's officially focused on judicial districts, but GOP leaders have signaled they may target the 2nd congressional district, represented by Democrat Benny Thompson, to reduce its majority Black composition.
And Georgia's moving too?
Georgia Governor Brian Kemp officially called for a special session today as well. GOP leaders there intend to use the Calais ruling to undo court-ordered remedial maps and target Democratic gains in the Atlanta suburbs. Tennessee is also in the mix. Governor Bill Lee, reportedly pressured by Senator Marsha Blackburn, announced a mid-May special session aimed at eliminating the state's last Democratic-leaning seat in Memphis.
What about Texas? They've had ongoing redistricting fights for years.
Texas is a big one. The ruling is expected to bolster the state's defense of its 2021 and 2025 maps, which have been tied up in constant litigation. Houston Public Media reports the decision opens the door for Texas to reconsider its congressional and state legislative maps as early as January 2027. So this is the start of what observers are calling a redistricting arms race.
This ruling didn't come out of nowhere, though. Put it in historical context for us.
It really is the culmination of a decade-long project by the court's conservative majority. It started with Shelby County versus Holder in 2013, which struck down the pre-clearance formula and ended federal oversight of states with histories of discrimination. Then came Brnovich versus DNC in 2021, which narrowed Section 2 on issues like ballot collection and voter ID. And in 2024, Alexander versus South Carolina NAACP required plaintiffs to disentangle race from politics in redistricting cases. Calais is essentially the final piece.
How are civil rights organizations responding this morning?
They're calling it a, quote, day of loss, end quote, for multiracial democracy. The NAACP Legal Defense Fund and the ACLU have both issued strong statements. Janai Nelson, president of the NAACP-LDF, said the ruling upends voting protections entirely. They're now pivoting towards state constitutional challenges and pushing for federal legislation, specifically the John Lewis Voting Rights Advancement Act.
And on the other side, conservatives are praising the decision?
Yes, Hans von Spakovsky, a prominent conservative legal scholar, praised the ruling. He argues that party affiliation, not race, is the primary factor in modern elections, and that the Constitution must remain, quote, colorblind, end quote. So there's a fundamental disagreement about what the Voting Rights Act was even supposed to do in the first place.
Will voters feel this in the 2026 midterms just months from now?
The immediate impact may be limited because many filing deadlines have already passed. But political scientists like Jonathan Service suggest the 2028 elections will be drastically reshaped. That's where you'll really see the consequences of these new maps in Florida, Georgia, Tennessee, and elsewhere.
So big picture, where does this leave the country today?
As of today, April 30th, 2026, the United States enters a genuinely new era. The federal government's ability to protect minority voters from political marginalization has been significantly, and perhaps permanently, diminished. Civil rights groups will keep fighting in state courts and in Congress, but the legal landscape they're working in has fundamentally changed overnight.
A truly historic moment. Ethan, thank you so much for breaking it all down for us this morning.
Thanks for having me, Grace.
And now to our second story this morning. In an unprecedented move, the Trump administration has fired every single member of the National Science Board. Joining me to break down what happened and why it matters is our science and policy reporter, Chloe. Chloe, good morning.
Good morning, Grace. Yes, this is genuinely historic. Last Friday, April 24th, just under a week ago, the White House dismissed all 22 active members of the National Science Board in a single stroke. According to Democracy Now! And Chemical and Engineering News, the board governs the National Science Foundation, which oversees a $9 billion annual budget for the country's non-medical fundamental research. Nothing like this has happened in the agency's 76-year history.
Wow. So how did these board members actually find out they'd lost their jobs?
It was remarkably abrupt. They received a brief email from the White House Presidential Personnel Office saying their positions were, quote, terminated, effective immediately, end quote. Among those fired were the board's top leadership, Chair Victor McCrary and Vice Chair Aaron Dominguez, both of whom serve in senior roles at the Catholic University of America. Also dismissed were prominent scientists like Roger Beachy and Kevin Stassen. EWTN News reports that Catholic University declined to comment on the firing of its two high-ranking officials.
An email. That's striking. What legal reasoning is the administration using to justify this?
They're leaning on a 2021 Supreme Court case called U.S. versus Arthrex. A White House official told EWTN News that the board's current structure raises, quote, constitutional questions, end quote, because members exercise significant executive authority without being confirmed by the Senate. The argument is that since these members approve multi-million-dollar grants and oversee that $9 billion budget, they're effectively, quote, principal officers, end quote, who under Arthrex must go through Senate confirmation. And right now, they don't.
But haven't they always been appointed without Senate confirmation?
That's the wrinkle. When Congress established the NSF back in 1950, the original statute did call for presidential appointments with Senate involvement, but the Presidential Appointment Efficiency and Streamlining Act of 2011, which took effect in 2012, actually removed the Senate confirmation requirement for these board members. So Congress itself made this change more than a decade ago. The administration is essentially arguing that change was unconstitutional in light of the later Arthrex decision.
That sounds like a stretch to some legal scholars. What are they saying?
There's a lot of skepticism. Chemical and Engineering News quoted Duke Law professor Jeff Powell, who pointed to what he called a, quote, puzzling disconnect, end quote, between the Arthrex ruling and this mass firing. In the actual Arthrex case, the Supreme Court did not order anyone dismissed. Instead, the court prescribed a remedy of reviewability, letting a Senate-confirmed official, in that case the USPTO director, review and overrule decisions. So critics say the appropriate fix would be statutory, not a wholesale purge.
So the administration could have just asked Congress to tweak the law?
Exactly. Constitutional scholars argue Congress could either restore Senate confirmation for the board or grant the NSF director authority to overrule board decisions. Either path would address the constitutional concern without creating a vacuum. And the American Chemical Society points out something important here, Grace. The board was deliberately designed with staggered 6-year terms, specifically to provide nonpartisan oversight that outlasts any single administration. That continuity has now been broken for the first time ever.
Let's talk about the bigger picture. Is this firing connected to other moves against the NSF?
Very much so. Democracy Now! Reports this dismissal follows roughly a year of the agency being targeted under the Department of Government Efficiency, or DOGE, which is led by Elon Musk. Before the firings even happened, DOGE-led initiatives had already halted more than 1,600 NSF grants worth nearly $1 billion. So researchers across the country were already feeling the squeeze. And now the governing board itself is gone.
And I understand the fire chair had been pushing back on budget cuts?
Yes, that's a key piece of context from Chemical and Engineering News. Dismissed Chair Victor McCrary had been a vocal opponent of the administration's fiscal year 2027 proposal, which would cut the NSF's budget by nearly 55%. That's more than half the agency's funding. Analysts suggest by clearing the board now, the administration may be looking to install members who won't push back on those cuts. Democratic Congress member Zoe Lofgren alleged the goal is to seat, quote, MAGA loyalists, end quote, in their place.
Speaking of Representative Lofgren, what's the political reaction been like?
Sharply divided, as you'd expect. Lofgren, who's the ranking member of the House Committee on Science, Space, and Technology, called the firing a, quote, stupid move, end quote, and a partisan attack on American innovation. She and other Democrats described it as a, quote, bozo the clown move, end quote, that effectively hands scientific leadership to global adversaries. Many Republican members of the House Science Committee didn't respond to requests for comment, but supporters frame it as dismantling what they call the, quote, scientific deep state, end quote, and reasserting executive accountability over federal spending.
What about scientists themselves? How are the major research organizations responding?
They're alarmed. The American Association for the Advancement of Science and the Association of American Universities have both condemned the firings as destabilizing. AAAS CEO Sudeep Parikh described the move as part of a, quote, string of erratic decisions, end quote, that leaves the NSF, quote, rudderless, end quote. So there's real concern in the research community that billions of dollars in active and pending grants are now sitting in administrative limbo, while the agency has no governing board at all.
And speaking of limbo, what's actually happening at the NSF right now?
As of today, April 30th, the National Science Board is entirely vacant. A crucial quarterly meeting was scheduled for next week, May 5th, just 6 days from now, and it's been canceled. That meeting was supposed to finalize a report on U.S. scientific competition with China, which is obviously a major strategic priority. So a piece of work that both parties have said they care about is now indefinitely on hold.
Are any lawsuits being prepared to challenge the firings?
No formal lawsuits have been filed by AAAS or AAU as of today, but legal experts are watching a recent precedent very closely, a case called AAP versus Kennedy from March of this year. In that case, a federal judge granted injunctive relief against the mass firing of the CDC's Vaccine Advisory Board. The judge ruled the administration had undermined the independent expertise required by the Federal Advisory Committee Act. So there's a recent template for courts to push back on this kind of move.
Has the White House said anything about what comes next?
The administration says it plans to work with, quote, the Hill, end quote, to update the NSF statute. But there's no concrete timeline, and in the meantime, this $9 billion agency is running without its traditional governing board. Outlets like ABC News, NPR, and the New York Times are watching closely to see whether the White House tries to fill these seats with Senate-confirmed appointees or pushes for a much broader restructuring of the entire National Science Foundation.
So bottom line, what should our listeners take away from all this?
I'd say two things, Grace. First, this is the first major leadership vacuum at the NSF in 76 years, and it touches research funding in every state. Second, the legal theory behind the firings is novel and contested, so expect this fight to move into the courts in the coming weeks. Whether you care about basic science, university research, or competition with China, this story is going to keep unfolding.
Really clear reporting on a complicated story. Chloe, thank you so much for walking us through it.
Thanks for having me, Grace.
Here are some other headlines. President Donald Trump and Russian President Vladimir Putin spent 90 minutes on the horn yesterday to dial in a potential pause in hostilities. Trump described the chat to reporters as a move toward a little bit of a ceasefire to honor Russia's May 9th Victory Day celebrations. While the Kremlin claims Trump actively supported the short-term truce, Ukrainian President Volodymyr Zelensky is calling for a reality check. He has instructed his team to clarify if this proposal is merely a few hours of security for a parade or a genuine path to a broader settlement. Against the backdrop of an ongoing conflict with Iran, Trump suggests a Ukraine resolution could be reached relatively quickly. But Kyiv remains committed to a long-term ceasefire with ironclad guarantees, rather than a temporary break that lets Russian forces regroup for a second act. Moving to South America, Brazilian President Luiz Inácio Lula da Silva just suffered a supreme defeat after the Senate rejected his nominee for the nation's highest court. Lawmakers voted 42-34 against Solicitor General Jorge Messias in a secret ballot, leaving the president with a messy political situation ahead of his re-election bid. This marks the first time in 132 years, stretching all the way back to the presidency of Floriano Peixoto in 1894, that the upper house has blocked a presidential pick for the Supreme Federal Court. Senate President Davi Alcolumbre had been sitting on the nomination for 160 days, and opposition leaders like Flavio Bolsonaro are celebrating the result as a victory for judicial restraint. The court has been operating with only 10 justices since November, and Lula will now have to find a new candidate who can pass the Senate's rigorous bar. Back at home, the House of Representatives is trying to keep the country's security on track. In a narrow 215-211 vote, lawmakers passed a budget resolution that authorizes a $70 billion reconciliation package for immigration and customs enforcement and the Border Patrol. The Department of Homeland Security has been facing a funding lapse since mid-February, and House Speaker Mike Johnson is pushing for a second vote today to keep the TSA, Secret Service, and Coast Guard afloat. This legislative rush comes after a security breach and shooting at the White House Correspondents' Dinner highlighted the strain on the Secret Service. The U.S. Travel Association warns that if the money doesn't fly by the end of the week, we could see mass TSA resignations just as we prepare to host the 2026 FIFA World Cup. In economic news, the Bureau of Economic Analysis reports the U.S. economy is showing some real muscle. Growth hit an annualized rate of 2.3% in the first quarter, a significant bounce back from the 0.5% expansion at the end of last year. This resilience comes despite the headwinds of the conflict with Iran and a 43-day government shutdown. Treasury Secretary Scott Bessent noted that while the war has fueled energy costs, business investment in artificial intelligence is keeping the economy's intelligence high. Commerce Secretary Howard Lutnick added that reshoring policies are narrowing the trade deficit, even with maritime disruptions in the Middle East. Finally, Secretary of War Pete Hegseth is back in the hot seat on the Hill for his second day of testimony. He is defending a record $1.5 trillion budget request while facing questions about the $25 billion price tag of the Iran conflict. Hegseth has called critical lawmakers his biggest adversary and is pushing for the military to move to a wartime footing. General Dan Kane joined him to advocate for a massive investment in drone technology and the Golden Dome missile defense system, as the administration faces a 60-day War Powers Resolution deadline this June. That's all we have for now. Today's episode was made by Alexander King with Claude Opus 4.6, Gemini Pro 3.1, Gemini Flash 3, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.